Watch the kid, will you step over?
May it please the court, Your Honor, we're before you on case number 2023 GS 31-74, the state of South Carolina versus Michael Evan Dinkins. Mr. Dinkins has been charged with 1 count of murder, 1 count of attempted murder, and armed robbery. He is represented by attorney Timothy Griffith. This is a bond hearing today, Your Honor. The co-defendant in the case of 2023 GS 31-75. That case is the state of South Carolina versus Byron Miller on the charge of murder, attempted murder, and armed robbery. Mr. Miller is represented by attorney Scott Robinson.
I have addressed this case one time before, and I remember the fact, if you want to put any facts on the record, you can. My understanding is that at that time, I think it was a video or something that the state had not produced yet.
Your Honor, yes, you have heard this case before, and the issue in the video was that there was a video that was provided to Mr. Griffith and Mr. Robinson. The issue with the video was an additional investigation was being conducted as far as the enhancement of the video. The video was submitted to SLED, and initially, law enforcement received information that SLED was not able to enhance. It would make it, it would impact the quality of the video, but we received updated information that SLED, as of today, they're still working on the enhancement of that video. If it can be enhanced, they would be able to get back in touch with us before the end of today to let us know if their process has been successful. When we initially learned that SLED was not going to be able to enhance that video, the video was sent off to a unit in Tennessee, the Regional Organized Crime Informational Center. That's one of their areas of expertise. So they are now examining the video. It does take them a couple of months in order to be able to render some results back to us. As far as what else is pending in the case, some shell casings were submitted to SLED. They were not able to lift any prints from that, but they did send those casings over to the DNA unit. The DNA unit has not rendered a result yet on that testing, so that's outstanding with SLED. And as I just mentioned, the video sent to the special unit in Tennessee, that's going to take a couple of months for them to examine that piece. That's the critical piece of evidence in this particular case. That's where we stand with the evidence. One issue that we had before was submitting all the discovery to Mr. Griffith and Mr. Robinson. The state has sent to the attorneys everything that we have in our possession at this point.
Okay. When you say everything is in your possession, how many law enforcement agencies work in this case and who in fact did gather evidence in this case?
The primary investigating agency is the Lee County Sheriff's Office, and I believe that in addition to the Sheriff's Office, SLED, of course, did the forensic testing, you know, on some items submitted, those cartridges that were submitted, and the DNA.
Now, when you say SLED has examined evidence that has been sent to them, did anybody from SLED gather any evidence in this case? Did anybody from SLED work on evidence?
Not as far as gathering the evidence. All the evidence was gathered by the Lee County Sheriff's Office.
So was any evidence retrieved from the autopsy?
I beg the court's indulgence. One moment.
I assume the victim was out died as a result of a gunshot.
That's correct, Your Honor.
Was a bullet or projectile recovered from the autopsy, or was it a through and through?
Let me review the autopsy. It's been a little while since I've looked at it. Your Honor, I am seeing in the autopsy that what was transferred back to law enforcement: clothing, personal items, toxicology specimen, DNA, blood spot card, and a sealed projectile.
Okay. Has that projectile been sent to SLED? And my understanding, SLED has the cartridges that were recovered from the scene, or some cartridges, right?
Yes, Your
And
Honor.
so they examined them fingerprints, and now they have DNA lab to determine DNA. Is the bullet been sent to them to determine whether it's the same caliber projectiles and whether it can be matched to? Has a gun been recovered?
A weapon has not been recovered in this case, Your Honor.
Okay. So all the physical evidence you have as far as that's concerned is a projectile and shell casing, is that correct?
Yes, sir. Beg the court's indulgence 1 moment.
Okay.
SLED, Your Honor, SLED does have that projectile there at their lab for testing.
And what tests were requested by law enforcement? What are they testing them for?
That projectile is being tested regarding the caliber to make sure that it matches the cartridges that were collected at the scene.
Okay. But you have, at this point, have you got any results from that test?
No, sir.
Is that test actually been done? It's a relatively easy, quick test to do.
As far as my knowledge, Your Honor, that's pending. We hadn't received anything back from SLED on that yet.
Okay. Anything else you need to tell?
Your Honor, I do have the criminal history of both of the defendants, if you would like to hear that.
Okay.
We do have also the son of Mr. Lonnie Ray was shot and killed in this incident, and his son is here today. The other victim, Mr. Mickey Wilkes, is undergoing cancer treatment. He was not able to be here, but he did provide a written statement that I can read into the record at the appropriate time. Would you like me to go over the criminal history of the defendants?
Yes, ma'am.
Starting with Mr. Dinkins, who's represented by Attorney Timothy Griffith. It appears that Mr. Dinkins does not have a South Carolina criminal history. However, it looks like he does have a criminal history out of New Jersey. And as far as that is concerned, I am showing two counts of some type of a failure to appear charge that was back in 2018. I'm also showing some other failure to appear charges back in 2022. That looks like that's the extent of Mr. Dinkins' criminal history. Mr. Miller, who's represented by Mr. Robinson, has more of an extensive criminal history. Mr. Miller has a conviction for common law robbery or strong arm robbery, where he received a 10-year sentence. He was taken into custody November 10th of 2010 on that charge. He also has a conviction for ill treatment of animals. The court date is reflected as of November 20th of 2014 for that charge. Mr. Miller also has some charges out of Toledo, Ohio. He has a conviction for a violation of a protection order. That occurred, the court date appears to be October 29th of 2019. He appears to have some type of drug charge. It's just listed as possession of a controlled substance. That occurred with a court date of December 22nd of 2020. That appears to be the extent of his criminal history.
Okay.
Your Honor, would you like me to read the statement from Mr. Mickey Wilkes?
Okay. And at the last hearing, the family addressed me, I don't know if he was, but go ahead and tell me whatever you think.
Yes, sir. Mr. Wilkes writes, "Sorry I can't be there today. I am having an infusion because I feel like they should stay in jail because they have no regard for people or property. They killed my best friend and shot at me, then stole our puppy and left. They said they have cooperated, but they didn't tell you the names of the others that was with them and did not tell you what they did with the puppy. I feel like my life and my family's lives will be endangered. They need to stay in jail." That's Mr. Wilkes' statement, and Mr. the son of Mr. would like to address the court.
Okay.
This gets harder every time. They took something from me, for my family. My mama says in great depression now. My brother, same. I don't think he deserved the breath they breathe, much less life. You know. She's just sitting in a rock, fall like here. You know. They've done great damage. They took a man's life that didn't need to be taken, didn't deserve it. Would have given his shirt off his back to anybody. I would have rot in hell.
Thank you, sir. Anything else, Mr. Davis?
Just that the state highly opposes bond at this time, Your Honor, because of the nature of the shooting. It occurred in a public place, and we feel like both Mr. Miller and Mr. Dinkins pose a great level of danger to the community, and possibly because of their involvement outside of the state with a criminal record, could possibly be a flight risk as well.
Okay, thank you. Yes, sir.
Your Honor, Mr. Michael Dinkins has been staying here in South Carolina with his mother. She's here today, and of course, she would like to address the correspondence, but also the pastor of the church, who is familiar with Mr. Dinkins, he would like to address the court, but of course, we were here on May 22nd, and of course, bond was denied, but you had said we could come back today. But we would ask for a reasonable bond, so that of course we can work with Mr. Dinkins on the outside, have better access to him. But if the court would not mind, that is, with the court's indulgence, his mother would like to speak to the court if that would be acceptable.
Okay.
Good morning, Your Honor. My son came here to take care of me because I'm a survivor, praise God, but I had ovarian cancer stage 4, and it spread it from there around my heart and in my lungs, and the doctor gave me 3 months to live Well, praise God. Thank you, Jesus. It's been 6 years. So my son came down here to help me and to take care of me. And he has 2 children. And he changed his life. He accepted Christ into his life. And now he's a trustee at the prison. He teaches Bible study. And he done changed several lives inside the prison. And I ain't need him home with me. He doesn't have a criminal record. And my son is a good boy. He has a good heart. And he didn't know anything about this. He was set up, Your Honor. He was set up.
Okay. Thank you, ma'am.
Thank you. God bless you, Your Honor.
Thank you.
Good afternoon. Your Honor, I've only known Michael since he's been here. I'm the pastor of his mother. To be honest, when I received the news of what happened, I was completely just flabbergasted by that news, because what I heard then just didn't correspond with what I knew of this young man from the time that I've known him personally. So.
Thank you, sir. I appreciate you coming. Okay. Anything else? Mr. Goodman?
Nothing, Your Honor, from
All right. Mr. Robert.
Thank you, Your Honor. Mr. Miller has been incarcerated for 527 days on these charges, Your Honor, and there has been a lot of talk today about the video, and that is what I have, quite frankly, been harping on for some time. I believe that that is what has been used to hold Mr. Miller in jail. Mr. Dinkins, and I realize this is not a trial, Your Honor, I'm trying to set everything in proper perspective. Mr. Dinkins' cell phone was used in making the calls to the victims in this case. There's no disputing that. Mr. Dinkins was identified on video from the Shell station where the incident occurred, and Mr. Dinkins' wallet was recovered at the scene. Those are the items of physical evidence that currently exist in this case, and the only person related to the case by those are Mr. Dinkins. There is a video of the shooting, which I have now had the opportunity to watch, and quite frankly, at this point in the current condition, you can't tell anything from anything. And the reason I point that out, Your Honor, I came in front of Judge Griffin last year asking for a bond in this case, and emphasizing at that point in time that I thought the state's, that there was some testimony or some information given to the court that they had video evidence that corroborated Mr. Dinkins' statement that Mr. Miller was the shooter. And I took exception to that. And I've been asking since then for the video. And let me read to you a portion of that transcript where Ms. Brooks was commenting on my taking exception to that. She says, "I think the evidence of the video has been understated. My information from law enforcement is that there is video evidence showing that Mr. Miller was the shooter in this case. I have the video, Your Honor. I would love for you to watch it. If they can show me from that video that Mr. Miller, as opposed to anybody else in this courtroom, was the shooter, I will join in the request to deny bond." That is simply not true. They have not been able to enhance that. That has been, in my opinion, the basis that bond has been denied on Mr. Miller in this particular case, is because there was, and again, Ms. Brooks represented what was told to her. I'm not saying, I'm reading the transcript of the information given to her from law enforcement. That conflicts, actually, the testimony that they gave at the preliminary hearing, which I also have a transcript of, where they admitted that you could not identify anybody from the videotape, that the surviving victim of this incident could not identify anyone, that there was absolutely no physical evidence whatsoever that existed that linked Mr. Miller to the case, and the only evidence in this case against Mr. Miller is Mr. Dinkins, who is the only one that had any physical evidence against. So they have a totally self-serving statement where Mr. Dinkins is fully cooperative and more than happy to blame Mr. Miller, And the court has been told for several different bond hearings that the video evidence, I'm looking for the right word, showing that Mr. Miller was the shooter. That's not true. Now, if it's enhanced, it may do that, but the video that I watched, I will submit to you, and like I said, I've got it, I'll be glad for the court to watch it before it makes its ruling. That's simply not true. The other concerning things in this matter, Your Honor, is just where we stand in this case, and I think the victim's son spoke to that. Law enforcement from the beginning has asserted that there were 4 people in this car. Mr. Dinkins hasn't named anyone but Mr. Miller. There's no proof that Mr. Miller was there. Mr. Miller has denied being there. But we know who the other people were. Law enforcement found the car, searched the car, didn't find anything in the car, did not execute a search warrant at the residence where the car was recovered or whom it was registered to, did not arrest the person that the owners of the car said was driving the car that night, did not execute a search warrant on Mr. Miller's house at that time. They may have done it since then, but did not execute. When he was arrested, he said, hey, y'all can search the house. I had nothing to do with this. His initial statement, he denied being there. He has continuously denied being there, and there is no evidence of any kind other than the self-serving testimony of Mr. Dinkins putting Mr. Miller there. Mr. Miller was asked about giving a DNA sample. He said, let me ask my lawyer, but I'm in the system. We don't have any information that if a code is hit on this shell casing, we don't have a gun to compare anything to. If a slug was recovered, and I'll be honest with you, I did not hear what Ms. Brooks said, it's not important, but there's no gun to compare it to. There's no murder weapon. And no search warrants have been executed looking for that murder weapon that I'm aware of at this time. I may be wrong, if I'm misspeaking on that, I'll take it. But the residence where the car that was used in this crime was recovered was never searched. And Mr. Miller tells me that when he was arrested, he signed a waiver to allow for the house to be searched. Again, it just seems like they just said, okay, Mr. Dinkins says Mr. Miller did it, that's good enough for us, Your Honor. And I realize this is not a trial, but I want the court to know how tenuous the evidence that they claim they have against Mr. Miller is. They have the uncorroborated, totally self-serving testimony of Mr. Dinkins, who was dead to rights at the scene. Now, he may not have been the shooter, I don't know. But the problem is Mr. Miller has been sitting in jail for 527 days behind a lie told by Mr. Dinkins and a misstatement of the value or the credibility of this video, which indicates that it confirmed or showed that Mr. Miller was the shooter. And, Your Honor, based on that, we believe that Mr. Miller is entitled to his honor. He did not flee. He did not go anywhere. He was arrested at his house. When they came and arrested him, he signed a consent form for them to search the house. He cooperated with them in his interview, said, I don't know anything about it, but if y'all need my DNA, it's in the system. I just got arrested in Kershaw. They got my fingerprints recent. If y'all need any of that, that's where it is. I don't know anything about it. I had nothing to do with it. And there is no evidence to suggest otherwise, other than, again, Mr. Dinkins. They didn't search the house for dog hair. We don't know what happened to this dog. But again, there's no link. There's nothing physically putting Mr. Miller at the scene. No clothing was recovered. They didn't search the house to get any of that. I don't know what happened to it. But the problem is Mr. Miller is stuck in jail behind, some misinformation, quite frankly. And we believe he's entitled to bond, Your Honor. We understand these are serious charges. And so we're not asking for a handout or a PR bond. We can think a reasonable surety bond would be in order. He lives with his mother and remember, if electronic monitoring is desired to make sure he doesn't go anywhere. If we need to put him on house arrest, I'm sure he doesn't have a job after 527 days in jail. But he wants, now that we finally had an opportunity to look at this evidence that the state has been representing as confirming his identity as the shooter, is simply not true. We believe he's entitled to a bond, Your Honor. So we would ask for a reasonable surety bond, house arrest if you deem it necessary with electronic monitoring.
Okay.
And in the alternative, Your Honor, we did file previously a motion for a speedy trial. We withdrew that in anticipation of receiving and reviewing the videotape portion of the discovery. If Your Honor, for some reason, denies bond, we would renew our motion or put it forward for for a speeding trial. Again, he's been there 527 days. This video has existed since day one. I don't know what's taken 527 days to have it analyzed. It is not what we were originally told it was. I don't know if it's ever going to be anything, but Mr. Miller's entitled to his day in court, and we would certainly like to have that sooner than later. And so we would ask under the statute that he not be tried in the next 2 terms of court, that he be discharged from confinement.
Okay. Anything else from today?
Your Honor, I understand this is not the trial of the case. The video is critical. I disagree with the characterization of the video. In meeting with law enforcement and looking at this video, what we were able to determine from it is that, of course, Mr. Dinkins is there. You could see on the video that Mr. Dinkins is in a kneeling down position. This matches his statement. Mr. Dinkins said, yes, I was there. My phone was used. Mr. Miller used my phone to contact Mr. Ray. We know that happened because Mr. Ray met them at this location. Mr. Ray, along with his good friend, Mr. Wilkes. But in that video, when we see what we believe is the shooting, it doesn't come from what we believe the person that's kneeling, who we believe is Mr. Dinkins. So the other person that Mr. Dinkins mentioned that was at the scene would be Mr. Miller. Again, the enhancement of this video is going to be the key to showing that. Now, there's some other statements that we believe in the case that shed some additional light on the facts, which would show Mr. Dinkins' involvement and Mr. Miller's involvement. But as I mentioned, I know this is not the trial of the case at this point, but this video, the enhancement of the video is critical. Being that we are either 24 hours from SLED's enhancement or roughly about 3 months from the regional center's enhancement down in Tennessee, I think because of the nature of what happened here, that bond should be denied at this point, and we can revisit it once we have that evidence in and the additional evidence in from SLED. That would be the position of the state.
Okay. This laboratory in Tennessee that has the video as well, who sent that to Tennessee? Was it the solicitor's office, the sheriff's office, or SLED?
It was Lieutenant Blakeney with the sheriff's office.
Okay. And is the backlog a result of their backlog or a result of some processing?
My information about how long it takes to review whatever evidence and see if they can enhancement, it usually takes a couple of months to get that done. I think that's just their internal process.
It's been there a couple of months now.
No, Your Honor, it was just sent to the Tennessee unit. When we learned initially that SLED said if we enhance, we think that it might impact the integrity of the video. So it was just sent to the Tennessee unit.
You said just sent this week.
Lieutenant Blakeney, when? Tuesday of this week, Your Honor.
Okay. Well, here's what I want you to do. By no later than Monday, next Monday, I want you to send a subpoena to SLED, subpoenaing the DNA and whatever evidence they have for the 23rd of September term. Okay?
For which term, Your Honor?
23rd of September, I will be here. You don't have a term there, but it's a term of criminal court here, state grand jury. The subpoenas are returnable that week. Then that means the 7th of October, we'll either be in a position to try this case or try the next term after that. So once you get the evidence on the 23rd, if you send that subpoena for them to appear on the week of the 23rd or send the evidence to you, that gives you time. And they may do it quicker than that. If you subpoena them, they will move it to the top of the pile and test it. Subpoena them for the week of the 23rd. Then it gives you an opportunity for the defense to look at that. And we need to set the trial for October 7th week. And you also can send a subpoena to Tennessee if the SLED doesn't come through. And if we can't try it on October 7th week, we'll try the next available week, which I think is going to be in January. You don't have another term this year.
It would be December.
You see in December.
I'm not sure right off. Your Honor,
Okay.
with the unit in Tennessee, I already know that they've said it takes several weeks, maybe a couple of months for them to do the enhancement on the video. So I don't foresee that that would be ready by the October 7th term.
That's 2 months.
Well,
We ain't got September yet. You can send it and see.
and Your Honor,
And if it doesn't, once you send us a opinion, you get a response back, and we can deal with that either the week of the 23rd or October 7th. You can come back and express to me what that position is at that time, or we can set this case for trial.
well, may I ask for one other consideration in the case, Your Honor? I can certainly work out things for the December term as far as if the court is telling me we can work out something for trial for December. I do know for that October term, I have already talked to Mr. Pete Ray, and I know that he would like to be here. He does have a trip planned where he would be out of the country, and it's a trip that he is not able to reschedule, and I know that he missed a trip earlier with some proceedings in the case, so I know he is not available that term, and I don't see how in good conscience we could try the case without him having the opportunity to be present. That's why I am begging the court if the earliest trial if the court would allow that to be during that December term at the earliest, but I don't think we're gonna have back what we need from the Tennessee unit in October, but even more importantly than that, Mr. Ray would not be available.
Okay, well, at least I want it, as far as your situation, to be ready for trial in October. Well, we won't run into this scenario in the December term. I want to know all evidence is in that gives both sides an opportunity to look exactly what evidence and what you can prove and what you can't prove. So by the end of our term, October term, whether it's trial or not, there won't be any other issues out there about evidence. You'll have your case established and who your witnesses are, what you can prove, and evaluate your case for strengths and weaknesses in any potential plea offers you may make. I mean, give the defense a chance to go over all this, what this case will be tried without any hitches, no later than December term. Okay? And if it's not tried, then that bond will get revisited. At this point, I'm going to deny that bond.
If there are any newsworthy events, we will get them to you as soon as possible. If not, you can follow us on Christian News TY Facebook, you can follow us on YouTube, and you can follow us on our website.